I think we'll make a start. Good afternoon and a warm welcome to this trust mediation webinar. We are recording the webinar. Hopefully you've had a notification that that's the case. And the webinar will be available to view on our website in the next few days. We'll put a link up for that. My name is Phil Hesketh. I'm a mediator and director at Trust Mediation. I'm joined this afternoon by my colleague, also director and very experienced personal injury and clinical negligence mediator, Tim Wallace, who I'm sure many of you will know. We're also delighted to be joined by David Pittaway KC, who I'll introduce properly in a little while after I've dealt with a few admin things. As ever with our webinars, we'd delighted if you could submit your questions. There is a Q&A icon on the screen, hopefully, that you can use. Please do submit them. You can either submit them at the end, or as they occur to you during the discussions that we have, please just submit them and we'll deal with as many of those as we can. The main focus of our webinar today is, of course, on neutral evaluation, and David will be discussing that in some detail. But before that, Tim and I would like to give you a brief overview of the different dispute resolution tools that we as an organisation can offer for you. We'll also touch on the impact of FRC, which was obviously a topic of our previous webinar. I would just touch on the impact of that and neutral evaluation, and also on the clinical negligence low value claims protocol and the impact on that as well. We'll finish with further opportunity for to answer your questions. So we shall proceed like that, if that's okay. Let me. I'll start then, if I may, just with an overview of the different dispute resolution tools that are available. And the one that we're best known for, I suppose, is of course mediation. And there are two well-known types of mediation: facilitative and evaluative mediation. Now, the mediation that we do virtually 99.9% of is facilitative mediation, and that's where you'll be familiar with this. A mediator, independent, neutral, assist the parties to help them try and find their own resolution, their own solution to a dispute. And the mediator is facilitating the negotiation process and assisting both sides in that. That's slightly different to the evaluative mediation process, whereby the parties explicitly agree in advance that the mediator can be at any point asked to give an evaluation on any particular matter, whether it's liability, quantum, causation, anything that the parties agree upon. That evaluation is not binding, but it may be an indication, obviously, to the parties the way the mediator is thinking. So that is done, and that is usually done well in advance. It's agreed in advance that's the approach that the parties intend to take. But as I said, the vast majority of the work that we do is the facilitative model. Obviously, the next one is neutral evaluation. I'm not going to steal David's thunder. I'll leave him to talk in more detail about that. David will also touch on mediation neutral evaluation, so a combination of the two. And again, I'll leave David to discuss that in detail. Tim, if I may, can you talk to us about arbitration?
Yes, arbitration differs from the other dispute resolution tools we're talking about in the sense that this provides a binding solution, rarely used in personal injury or clinical negligence, hardly ever. Safe to say that there is one exception to that, which I'm aware of. Trust Mediation has a sister company, Trust Arbitration, and together with the company Law, which is a tech platform, we run an online arbitration service for low-value road traffic personal injury claims. These are claims that have been through the claims portal, the old claims portal, or the new, or not quite the new, now the OIC portal. So claims that have been through those portals and not resolved are eligible for arbitration, and we're also dealing with Part 7 fast-track claims, both liability and quantum. So whereas once upon a time ADR meant mediation, we're now seeing it means a range of different things, including arbitration as an exception. Let's go on, Phil, if we go to the next slide, and we'll look at the FRC and how that's having an impact. And we wanted to do this to really try and put neutral evaluation in context today, because if you look at the very bottom row on that table, this tells us what David's going to be talking about later on, the ClinNeg and PI claims for the high value, the 1 million plus. No FRC there, of course. And David, as Phil has already mentioned, is going to be talking about mediation as well as neutral evaluation and how they can be mixed together. But the first 4 rows of the table show where FRC is now having an impact and how neutral evaluation is involved. And so with the Department of Health, the sub 25,000 ClinNeg scheme, which has now been imposed and is due to start, neutral evaluation features in that. I think there are arrangements for opt-out, but there's certainly the idea is that after the stock take, if a claim is not settled, it goes to neutral evaluation. And the principles here, of course, are exactly the same as what David will be talking about later on with the higher value. When we come to the intermediate track, the ClinNeg between 25 and 100, where liability and causation are admitted early on, subject to the fine details being agreed. I know there are judicial reviews and so forth looking at this. And the personal injury sub 100,000, accidents after 1st October. Mediation and neutral evaluation may be tools that parties want to look at as a cost-effective tool to get a swift settlement, bearing in mind the thinner margins that there will be on these cases. So that's a quick rundown, and that just leaves the 4th row. And as Phil has mentioned, facilitated mediation is what we ordinarily do with clinical negligence and personal injury claims. That's historically been the case. And for the £100,000 plus claims, that will continue to be an option. So that's to give you a little bit of context of what David's going to have to say. And if we move on to the next slide, well, you'll see that trust mediation, we've realised that the name, although very accurate historically to describe our activities, is now less so. And so we're developing the brands of trust evaluation together with the one already established of trust arbitration. So you may be seeing those around, which is why we've got the TM plus sign to indicate that our services are more than just mediation. But I'm not going salesy on you. This is simply for information and to give you the context that ADR no longer means just mediation. Phil, I'll turn back to you now.
Thanks very much, Tim. So yes, let me introduce David Pitway Casey for you. David is former head of Hailsham Chambers, over 15 years experience as a Deputy High Court judge, as well as extensive experience from his bar practice, including complex clinical negligence matters. I think, David, it's true to say that your practice now focuses almost entirely on resolving disputes without a trial, whether that's sitting as an arbitrator, a mediator or an evaluator. You became a fellow of the Chartered Institute of Arbitrators in 1998. Was accredited as a mediator in 2002, and we're delighted to say that this year David has joined us on our panel as a mediator and evaluator. David, over to you. Thank you.
Well, thank you very much, Phil, for that generous introduction. What I wanted to talk about this afternoon was neutral evaluation, but really in the context of how a neutral evaluation is conducted. Because certainly on previous occasions when I've spoken about this, I think there has been a relatively low level of understanding about how a neutral evaluation is in practice conducted, or to put it more accurately, how I conduct a neutral evaluation. Just touching briefly on the history of neutral evaluation, obviously in terms of dispute resolution, we've moved on a long way since Sir John Dyson's, as he then was, judgment in Halsey and Milton Keynes Hospital Trust, when he considered there were problems with Article 6 of the European Convention on Human Rights. And there has been a steady push towards the acceptance of both compulsory mediation and evaluation, first in the Inheritance Act case of Lomas in 2019, and in Geoffrey Voss, the Master of the Rolls judgment in McParland in 2020. And we've also seen Master MacLeod, who's been very much at the forefront of issues in terms of promoting mediation and evaluation, her judgment in 2020, where she set out a template of directions that she considered would apply in a judicial neutral evaluation. So I think that the direction of travel is pretty clear, and Sir Geoffrey Voss has very much been the driving force behind this move to integrate the various means of dispute resolution. And we can also see that in the FRC regime, which has come into force in part and due to make a substantial change with the lower value clinical negligence claims from next April. And I know that Lady Justice Sarah Aspin, who chairs the Judicial Liaison Committee, is also a very keen promoter of mediation and evaluation. And I think if one looks for the philosophy behind it, it is to not look at dispute resolution in the terms of it being alternative dispute resolution, which is a term that Sir Geoffrey Voss has said he would prefer is not used, but a more integrated system in terms of litigation, of introducing other forms of dispute resolution into the process alongside the traditional method of litigation in cases. So just wrapping that up by way of a very brief introduction, neutral evaluation is in fact not a new concept. I mean, it's been used in commercial and construction cases for some years. And Dame Janet Smith, who in effect introduced me to neutral evaluation 4 or 5 years ago, has described it as a premium service, because what you're actually getting is the opinion of somebody who is experienced in the field, who can give the parties confidence as to what the likely outcome is going to be if the case moves to trial. So I think there are a number of factors that would need to be considered in terms of a neutral evaluation. The first, of course, is that it's non-binding and it's a confidential practice procedure to which the parties sign up to. The second is that the evaluator is an independent third party, and I think that's an important part of the process. And he or she has the necessary expertise in the field in which they are being asked to evaluate. And underlying that, the third is the importance of having an evaluation. And having an evaluation is that it focuses the parties' minds upon the likely strengths and weaknesses of the case, and as set out in the evaluator's decision. And it can be used in different ways. It can be used for the whole of the case, for liability and damages. It can be used for parts of the case, on breach of duty, on causation, on individual heads of damage, if the parties think that the resolution of particular issues will speed the process and reduce the length of any particular trial, and reduce the costs that are involved. And it can take place at any stage. It can take place from pre-issue to shortly before trial, and indeed it can take place after trial if a party has decided to appeal a judge's decision. I have one case at the moment which is pre-trial, is pre-issue of proceedings, where the claimant has already obtained sufficient expert evidence that they are prepared to engage in this procedure. So it's different from the facilitative or evaluative mediation that Phil and Tim were describing, because what it does is it provides an informed, non-binding decision on the case. And in the models that I have used, the cost of the evaluation itself has been borne by the defendant, because the defendant is obviously anxious to resolve the case without expending a large amount of resources. So turning from that brief introduction as to what I see as the principal advantages of neutral evaluation to the process itself, it is a very flexible process. It can be purely dealt with on paper, and that is what is clearly envisaged in the new FRC rules for low value clinical negligence claims. And it can be a mixture of paper and oral submissions. To my mind, there is considerable strength in an oral component in an evaluation, and I'll come back to that, if I may, in a moment. An alternative process, which I understand that one retired Lord Justice of Appeal adopts, is that he conducts an evaluation entirely on paper, and then a mediation by the more traditional means of an oral attendance by the parties. So, as I've said, it is entirely flexible, and it can be adapted and used in different ways. To me, the most important aspect of it is the key appointment is that of the evaluator. Now, the value of cases, I have dealt with substantial cases or where the claims have been over £1 million, although, in fact, in those cases, the final settlement figure has not by any means been over £1 million. But the value of the case may determine the experience that is required of the person who is going to be the evaluator. Because as I think I've already indicated, the key to this process is that the parties have confidence in the evaluator for the scheme to work. Once the evaluator has been agreed, in the cases in which I've been involved, and the parties have signed the agreement, I've contacted the parties' solicitors by telephone or Zoom and discussed the issues that they are seeking to have resolved and suggest directions for the meeting. And those directions typically involved a reduced agreed bundle of documents, including witness statements, pleadings, witness statements, and experts' reports, and the key documents that you would find in a core bundle, and also directions as to position statements, all to be uploaded onto an electronic case file. And similar to a mediation, it's important to identify the legal and factual issues that are to be determined in the evaluation. The hearing can take place in person. It can take place by MS Teams or Zoom. And in each case, as I've said, the process is entirely flexible. Now, in the majority of contentious personal injury and clinical negligence cases, there will be significant differences between the experts on breach of duty, causation, and heads of damage. And that's something that I would concede cannot easily be resolved on paper, although the positions may become clearer if the evaluation is at a later stage when joint statements have been prepared. And that is why I consider that the oral component is an important part of the process, because what the oral part of the evaluation allows is for the evaluator to ask the counsel for each of the parties about the strengths of their case as to how they see their case, and for the parties' counsel to put forward, put their best foot forward as to why they consider that their experts' report should be preferred to those of the other party, and also to point out what they see as the weaknesses of the other party's case. And in more complex cases, arrangements can be made for an evaluator to seek clarification of experts' reports. I had one evaluation last year where, in advance of the evaluation, I spoke to both parties, neurologist, expert neurology witness, and with the party's solicitor being present, so that I could obtain clarification upon the views which they had expressed in their reports. And that proved to be a very useful exercise, particularly when we reached a stage where I was talking to discussing the case with the parties' counsel in the oral component of the evaluation. So the process itself is similar to mediation meetings. The evaluation usually takes place over one day, with the morning being concerned with the evaluation, and in my cases, the afternoon being concerned with the mediation. But of course, provision can be made for it to take place over more than one day, and I have one case next year where 2 days have been set aside. Like a mediation, there can be a plenary session where the parties and legal teams have an opportunity to set out their respective cases. I'm doubtful that greatly assists the evaluator, but I know that some parties like to do that. And in fact, in all the evaluations I've done, as opposed to mediations, nobody has asked for a plenary session where all parties are present. So what I do to start the analysis of the parties' positions is to discuss individually with the parties, legal teams, the strengths and weaknesses of their positions. And I've always to date started with the claimant. For example, in a quantum case, I've asked if I can talk to the claimant himself or herself about their injuries and as to how the injury has affected them and what they can do and what they cannot do, because it better informs me as to an evaluation on quantum, and it could equally apply to an evaluation on breach of duty. And of course, I give counsel, having obtained permission, I give counsel an opportunity to ask questions of the client if they think there are matters which I've asked questions about, which they want to follow up on, and to expand upon the submissions that they have made in their position statement. And having done that, having had that initial discussion with the claimant's legal team, I then go to the defendant's legal team, which usually consists of counsel and represented solicitors and representatives of the insurers. And I give the defendant an opportunity to deal with the strengths and weaknesses of the case and any other issues that the claimant's team may have raised with me in the discussion that I've had with them previously. So then I effectively balance the discussions that I've had by talking to both parties, and then I go back to the claimant and I put to the claimant's legal team what the defendants have said about the strengths and weaknesses of the respective cases, and give them an opportunity to answer them and to raise any points that they believe are relevant to the decision that I have to make. To date, 2 meetings with the claimant and 1 with the defendant has been sufficient, although there could be circumstances in which you would want to break down the meetings, perhaps issue by issue, if there are separate issues if there are issues on liability and quantum, and structure the process in a different way. And generally I've found that the morning is spent with the neutral evaluation, with the obtaining the additional information from both parties. And then I go away and have to consider the decision that I'm going to make and to prepare a short judgment, in effect, a short decision on the issues that I'm being asked to evaluate. And using judicial experience that I've had in the QBD, now the KBD, and the Administrative Court of providing judgments at short notice, I'm able to do that. And one of the ways in which I can do that is that I can, in advance of the day, prepare the non-contentious parts of the judgment, so that I can slot into that the views that I have formed on either factual witnesses or expert witnesses in coming to my conclusion. Having done that, and that usually takes until sometime after lunch, perhaps until 3 o'clock, 2:30, 3 o'clock, I then deliver the decision that I've made. I could do it in a plenary session, but the parties in the cases that I've done have preferred it to be done individually. I give it to the claimant first, and then to the defendant. They obviously have time to absorb it. The defendants have signed up to the scheme because they want to resolve the particular case. So even in cases where I have found for the defendant, I would expect the defendant to make an offer of some kind to bring the matter to a conclusion at that stage. I've not had experience of a claimant discontinuing as a result of the evaluation, because in all the cases that I've done, the defendants have come up with an offer, either in terms of damages, even though it's a small amount of damages, and in relation to costs. And then the process moves much more like a more traditional mediation, except invariably, having given the views that I have done, that the parties know what I think in terms of the likely damages that would be recovered if damages are an issue. And then I shuttle between the parties and inform them of the offers and counter offers that are made. And in my experience, in the number of cases that I've done, the cases have either settled on the day or within 14 days of the evaluation meeting or hearing, however you would wish to describe it. And it seems to me that what the process does is it gives a reality check as to where on the information that's available at the time of the evaluation the likely merits of the case are to fall. And as I've said, I think that the key issue in the case is to ensure that an evaluator has the relevant expertise in the field, because otherwise it's not of great use to the parties. And then to have the oral component in the evaluation, which enables the evaluator to test each of the parties' cases. I think it performs a different function from parties themselves reaching a view as to the likely success or otherwise of the case, or indeed, as I have done in cases in the past, been instructed by a party to give my view as to what the likely result is, because you're approaching the evaluation in a different light. You're approaching it as an independent third party, giving your view, having obtained the information that you require from each of the parties. And that is why I think that the parties can and should have confidence in the system. I don't think neutral evaluation is appropriate to all cases. And obviously it forms part of the package, part of the toolkit that's available in dispute resolution. It'll be very interesting to see how the FRC scheme works, when it comes into force next April, and whether that works with paper-based arbitrations on anything other than the simplest of cases, where there have been admissions of breach and causation. So I hope that is helpful in setting out how the process works as I see it and as I've done it. And I believe that it has a valuable role in reducing both the cost of litigation and the time that litigation takes. And the final point is that I think from a claimant's point of view, it's a very different environment from the environment where a claimant is in a courtroom. And I think that there is a real plus factor in the claimant feeling involved in the process and being asked questions by the evaluator in a way which is not as intimidating as it would be if a claimant gave evidence in a court. So, Phil, that's how I see it, and I hope that that gives a broad overview on the process of a neutral evaluation.
Yes, excellent. Thank you very much indeed, David. That's very, very informative. And I have half a dozen questions of my own, but I think we should open it to the floor. And there's a question I'm going to put to you in just a moment. But before I do, I will try a poll on this question, just to ask our attendees to whether or not neutral evaluation is something that they would consider using. So I've just opened that poll. I think that should appear on your screens. And David, if I may, we have a question here. In the event that the evaluator favours the defendant, why would you expect the defendant to still make an offer? Slightly concerned that could lead claimants to expect offers in properly defensible claims.
I think the answer to that.
Thank you for the question, whoever submitted it, by the way. Thank you.
I think the answer to that is this: if you are a defendant insurer, whatever capacity you are, whether you're standing behind in a clinical negligence case, the doctors, such as one of the medical defence societies, or the NHSR, or an insurer who specialises in medical insurance, you essentially want to remove that a particular case from your caseload at a minimum cost, and therefore, if you have an evaluation at an earlier stage, at any stage of effect before trial, you're minimizing the potential outlay that you're going to have to make, because what you're doing is you are bringing to an end that particular claim. I don't think it does mean that claimants will expect large sums of money necessarily in every case that they agree to go to neutral evaluation. But what it does mean, remember that the costs of the evaluation are borne by the defendant. So the defendant has already indicated that it wants to use the process. And I think in all the cases that I've done where I have found for the defendant has been prepared to make a relatively modest payment, small payment, and come to some arrangement on costs to essentially ensure that the litigation comes to an end and that there isn't a liability, onward liability, continuing for costs in preparation to trial.
Phil, you're on mute, I think.
Beg your pardon, thank you. The rain was hammering down. David, I think you've answered this question, but there's a attorney would like to know who usually bears the cost of the evaluation.
The defendant. And if you look at the new FRC scheme, then the government has come to a similar view. And if you look at the consultation paper for that scheme, the government came to the view that the costs in the FRC schemes of evaluations should be borne by the defendant.
Thank you. Another question, speaking of FRC, do you anticipate there will be an oral component in FRC cases on the standard track, given the minimal costs available to both the evaluator and the claimant?
No, it's the answer, because there's no provision for it in the protocol. It's purely it's going to be purely a written evaluation.
Well, if the audience don't mind, I'm going to sneak in a question of my own related to that slightly. Is that going to be useful then if there's a dispute of fact, if there's no oral evidence to be tested?
Well, I think it's going to be difficult, and I can see why. That's why I said at the end of my talk, I can see that in simple cases, the FRC scheme will work, whether there are omissions, straightforward omissions. But I think it will become more difficult where there are not admissions, and that's going to be particularly applied to the up to 25,000 claims, because after that figure, the 25,000 to 100,000 claim, there have to be admissions for it to fall within the scheme. So I think it will be difficult for those claims to be decided on paper. It'll be interesting to see how it works out. And related to that, Phil, I think there is also going to be an issue as to how a cohort of evaluators is put together, because the costs are relatively limited, who have the necessary experience to decide claims purely on paper where there are disputes, both as to factual and expert evidence.
Yeah, thank you. I hope you're sitting comfortably, David. The questions are piling in.
Right.
Melanie, thank you for your question. If fundamental dishonesty has been raised, would neutral evaluation still be indicated, or is this the sort of claim that's automatically unsuitable for the process?
I think it's probably unsuitable for the process. I mean, I think I don't think that a defendant would. I think it would be the sort of circumstances in which a defendant would not be willing to make an offer if the evaluator had found that there was fundamental dishonesty. I think that there are two reasons why it may be inappropriate for the process. One is where you have what is an informal procedure, whether it is a case where an evaluator would be prepared on the basis of the information to find that there had been fundamental dishonesty. It's possible, depending upon the weight of material available. And the second is whether in those circumstances a defendant will be prepared to make an offer. It might actually create a situation which I've not come across, which would be where, as a result of the evaluator's finding, the claimant discontinues.
Okay, thank you. Next up, the reluctance in using neutral evaluation in clin neg cases has been that it's non-binding in nature, and therefore there's a risk it'll merely add an extra step and escalate costs. What would you say about that?
Well, I think really what I've already said about that is that it brings to it brings to an end litigation at a much earlier stage. Now, where in the process it falls will dictate what the level of costs have been incurred by the parties. But if the neutral evaluation takes place, and the parties have agreed to the neutral evaluation taking place at some stage before trial, then the trial costs will have been avoided. If it takes place at an earlier stage than preparation of joint statements and so on and so forth, and you can ride it back over a period of time during the process of the case, again, the level of cases, the level of costs will have been avoided. And costs are really what the government's position is all about. And it'll be a non-party political. It'll be exactly the same under a Conservative government as it will be if there is a Labour government. Is that the level of costs in these cases, in clinical negligence cases, is rapidly rising, and in the larger cases can be very high indeed. Sitting as a Deputy High Court judge last year, I did an interim payment application where there were two hearings in a catastrophic injury case, a brain damage case, and at the end of that hearing, the claimant's schedule of costs was over £200,000, and the defendant's costs were over £100,000. Now, fortunately, I wasn't the person who had to decide how much of those costs were justifiable, but it did bring to me, put in sharp relief to me, the extent to which costs are now becoming increasingly high. So if you adopt the neutral evaluation process, it works both as to time, because it means a claimant knows that the case is being resolved at an earlier stage than he or she otherwise would, and it also works as to reducing the costs.
Thank you. A question from Andrew. Thank you. Can neutral evaluation offer more flexibility in the terms of resolution in similar terms to that of a mediation compared to a trial? And do you have any examples that you could provide us with in the neutral evaluations that you've conducted?
Yeah, I mean, I think in a number of different neutral evaluations that I've done, what you're achieving is what I've already spoken about, is getting a decision, an informed decision by a third party in a way which you would not get in a facilitative mediation, because that's not the purpose of a facilitative mediation, and in a different way from which you would get in an evaluative mediation, which I've also conducted, where you're getting a view invariably on a particular issue, where the silk in front of me or in the mediation say, well, what is your view on this particular issue? So what you're getting is that you're getting a complete decision on the issues that have been agreed between the parties that the evaluator has to provide. So it's not a mini trial, because obviously you don't have evidence being presented in the same way, but you are getting a defined decision at an earlier stage, and that, I think, is the value of the scheme.
Thank you. A question, I think this is relating back to one of our earlier questions, but somebody's asking, does this open a floodgate for claimants bringing cases where neutral evaluation is adopted? Because presumably given expectation for monetary offers to be made, if offers are always made, presumably defendants could avoid the costs of evaluation.
Well, as I said, in the cases that I've done, defendants have made offers, even if they've been very modest offers, to remove the case from their books. But that doesn't mean to say that you wouldn't have evaluations where the defendants would not be prepared to make offers, although that may be counterproductive if they want to bring litigation to an end. I don't think it does actually open the floodgates to claimants making unmeritorious claims. I think what it does do is it means that in those cases where claims have been brought or are intimated to be brought, that the parties do not go to the expense of issuing proceedings and carrying out the consequent steps for at a later stage to realize that they have to discontinue. Because if they do that and they have to discontinue, then the cost burden is going to fall where it lies where it falls. And in those circumstances, defendants will have incurred significant costs.
Thank you, David. I see Tim has patiently been waiting with his hand raised, so you can put your hand down, Tim, and you have the floor.
A couple of questions from me, David. I'm interested in the crossover from the neutral evaluation to the mediation. I imagine, I don't know, that the neutral evaluation is essentially an adversarial process, because each counsel will be putting forward their best case in the hope of persuading you that their view is right. So that seems to me a kind of a very highly adversarial process in nature. And then with your evaluation, one party is going to regard themselves as the winner and one the loser, because you will have moved towards one or the other arguments. And I'm just wondering, in that environment, I'm curious as to how the collaborative mediation discussion follows after an adversarial morning, and you find out after lunch you've won or lost in the view of the evaluator. Tell me about that crossover and how the collaborative side works.
I haven't found that a problem actually, and I think because what actually happens in practice is that the evaluator builds up a relationship with both parties' legal teams, and even when the evaluator has found that one party has lost or the other party has won, you have that relationship there. However much you as one particular party may disagree with the evaluator's decision. And I think that the parties are there. The reason they've signed up to the agreement is they're there to resolve it. And invariably they don't want a claimant's legal team doesn't want the claimant to be to walk away empty-handed. Defendants equally want to bring the case to an end. So I think there is if you like, there is an imperative to reach a conclusion, and they enter into it with their eyes open. They know that the evaluator's task is to reach a decision. That's the purpose of the exercise, and they also know that there are only two results really of that decision: one that they win, and the other that they lose. And I think also you've got to bear in mind that it's a much more relaxed environment than a court environment. And I think even though it's adversarial, the conversation that I have with counsel on both sides is a much more relaxed conversation than you would have if I was sitting as a judge in the KBD.
Thank you, and that's helpful. And a follow-up on that. I understand the logic of the process that you use. But the question has been put to me: why not mediate first, and then if you, then only that if you don't get a solution, move into evaluation or even arbitration. But doing that, evaluating, only if it's necessary, which it won't be in many cases. And I'm interested in your thoughts on.
Well, I think that one of the questions earlier, Tim, was about introducing an extra stage in the proceedings. I think that there is an advantage to proceeding straight to a neutral evaluation without a mediation, because in the model that I have familiar with, once I've made my decision, it then turns into a mediation anyway, in terms of reaching a monetary or financial outcome to the proceedings. So I mean, I think there is. I mean, as I've said, I don't think it's necessarily suitable for all cases. But I think it is a model that could and should be used to greater effect, and I think that that's the way that the Ministry of Justice thinks too, in terms of how it goes down this course. Because I think it's generally recognised that judicial neutral evaluations are likely to be limited, because the court service simply doesn't have the capacity for masters or judges to carry out large-scale judicial neutral evaluations. So I think that the way it works with if you like private evaluations is it takes it out of the traditional litigation route and enables the parties to seek to resolve a case.
And thank you. Final question from me: what stage would you normally expect a neutral evaluation to take case in proceedings? You mentioned getting joint statements, for example, so and the pleadings and witness statements. So is it?
I think you can't have it in a clinical negligence case. You can't have it without there being disclosure of expert evidence, and that would be equally true in pre-issue cases as it would be in post-issue cases. I don't think you have to go as far as joint statements, although joint statements can be very helpful to an evaluator. But I think in many neutral evaluation cases, once the claimant is in a position to provide the factual witness statements and expert evidence, and the defendants have been able to answer that and obtain their own evidence, even if it's desktop evidence at that stage, you can then move to a neutral evaluation.
Thank you.
Thank you. Well, David, you've dealt with all of the questions that our audience have submitted, and 2 or 3 that we've thrown in as well. I don't think there are any more. If anybody does have another question, just please do ping it in now. Final call for your questions. Thank you very much indeed, David, for a really enlightening discussion, and I hope the audience have found that very useful. If I may, I'll just let you know of some our next webinars which are coming up later in the year. So on November the 8th, we are looking at mediating claims involving GPs or GP practices, clinical negligence matters. Our colleague Mira Lachani will be joining us for that one. On the 15th of November, we've got a mediation webinar on personal injury mediation. So specifically looking at personal injury mediations, when to do, what are the indicators for identifying cases which might be suitable for mediation in the PI world. On December the 13th, we'll round up the year's developments, which may include horticultural interest, the Churchill case, which may or may not have come out by then, obviously of interest, and we'll discuss that if necessary, and also have a look into the future, what's coming up in the new year, and at a date yet to be fixed, we'll have another discussion in December looking at the FRC, because our last webinar, obviously we couldn't provide all the answers because nobody can profess to know all the answers at the moment. So we're going to keep discussing that, I think. So we'll have another one. All the links for these webinars are up on the website, and we will, as usual, send out an email to remind you. This webinar is recorded, so we'll put a link for this on the website too.
Phil, what was the result of the poll?
The results of the poll on the first poll was yes. Would you now consider using neutral evaluation? 66%. That's 23 of 35 respondents said yes. 4 of the respondents said no, and 23% said they don't know. Okay, so 66% said yes, 11% no.
Thank you very much.
Yes, just slide on there. We are very, as an organisation, very keen to speak to colleagues in the profession about the developments of ADR in the FRC space, because obviously it's a developing world. So if you want to speak to us, we'd be delighted to hear from you. Contact either myself or Tim or any of our team at Trust Mediation. Tim, have I left anything out?
You're going to do a final poll, I think, Phil.
Well, we did 2. So did you see the other? Did you see the other one? I'll share the results again of the other poll. Is that showing now?
Oh, I see. Yes, thank you.
Yeah. Okay. In that case, just remains for me to thank Tim and especially David for your time, generous time, assisting us today and giving us a really helpful and informative view of the neutral evaluation. So thank you very much indeed.
Thank you.
Thank you, Tim. Thank you. Goodbye.